I would like to introduce Hon'ble Justice B. Prakash Rao, sir. Sir is a former judge of High Court of Andhra Pradesh, had an illustrious legal career spanning decades. He practiced extensively in civil, writ and revenue matters and he held key roles including government leader, standing counsel for APSRTC. He served as a judge from 1999 until his retirement in 2011. So I would like to request Honorable Shri Justice B. Prakash Rao sir onto the dais.
Sri Gurubhyo Namaha, Sri Shasharanam. A very good morning. In fact, to be frank, because one of the speakers, Mr. Sharma ji, who is also from Delhi, he is also a civil lawyer, and I am also absolutely to the core a civilian. In the sense, I was a civil lawyer and a civil judge to the core. But at the outset, I congratulate all the organizers and those concerned with this wonderful program, arranging Law Futuristique Meetup, and trying to, especially keeping in view what I have been discussing all along, is this is only for the benefit of the society and for the benefit of the younger minds, for the benefit of the future generation. This is what, in fact, I am also in fact on the same job after my retirement from 2011. I would like to share one incident which I shared now. Say, when I was asked to address some 36 district judges in National Police Academy on a forensic law and other aspects, before I started, though it was not my subject, but I asked one question: how many of you read the Constitution at least once? District judges. They said no, we have not read, not even once. I said, then the one district judge stood up and said that why should we read, sir? If there is any necessity, if that particular provision comes up for consideration, we'll look into it and we'll interpret it or we'll consider another. Otherwise, not necessary. I said, no, you can't afford to say like that. So your existence, my existence is under the Constitution, and that common man of the RKL Express, common man, every common man, every citizen, that shelter is only under the Constitution. We are all safe, and you can't afford to say that I have not read the Constitution and other things. So be that as it may, before I go into this particular topic, why are you falling back on those old laws? Trademarks Act or Copyright Act, they are all, and also others, those such old acts only. They're not apparently the law has not kept pace with the developments in the society, development in technology and development in the artificial, these gadgets and other things and all that. Ultimately, you are only looking towards what is coming from the international level. Why are we not applying our mind locally here? Can we not, even any violation of the trademark, copyright or whatever it is, of that nature? I am not saying that it is a copyright. In fact, strictly speaking, I am totally disagree with though laws have been amended subsequently, Trademark Act and Copyright Act and other things, but still yet I say that they do not fall, this mind work, the exercise done by the mind cannot fall well within the trademark or copyright as such. The reason why I am saying is because, now look at the Constitution, okay? The Constitution prescribes certain provisions. They say 3 wings, fundamental rights, principles, amka and all this, okay? It's all letter, that is called a letter of the law. But beyond that, there is much outer space. You know that? That's why you find Article 21, the liberty, is being every day is sought to be expanded. We don't know what the framers of the Constitution thought of Article 21 in the beginning itself. But there is a principle or the jurisprudence or things called like constitutionalism, which is go far beyond the Constitution. There are many grey areas also which are not covered by the Constitution. That's why what I am trying to drive at is, similarly with these intellectual property rights also, there is some outer space, there is something which is not covered by these laws also. So now this, yesterday, just 2 days back, the Supreme Court has observed with these developments in artificial intelligence also, Justice Suryakan, his observation, artificial intelligence has very serious biases. We must remind ourselves it's a man-made machine. So where do we stand? Now, Suppose take yourself into a little higher pedestal now. There is an Oscar award, international Oscar award. They frame new rules. Considering impact of artificial intelligence onwards, Academy ruled that the use of generic artificial intelligence will neither help nor harm the chances of nomination. We continue to assess the degree to which a human was at the heart of the creative authorship when determining the award. This is, I'm sure, I think every speaker will take note of this. Exactly the core umbilical cord which runs under this IP rights and where it comes from, its source and other things also. Now there is one case which we came across. An injunction was sought in a 5th Additional Court, City Civil Court, by a junior to a research scholar who made some research for which there was some international recognition and he was to be awarded something, some French I suppose. Then the junior said, no sir, it is not his mind, it is my contribution. And the 5th Additional Court granted an injunction, restraining that international authority from awarding that to him, to a senior. Then the matter was carried to High Court. The moment just 2 sentences was told, this is an injunction against an international award in respect of some award and based on our research. Then he flared upon, how can such civil court can grant an injunction? No, civil court has no business to go into such area. And ultimately it was vacated. Why I am referring to this particular case? What exactly is the area which you are trying to cover? These rights which you are now trying to deal has got something else. Please try to look from that angle. What I am trying to say is, this is something like it's still a developing jurisprudence possible. We will have to not only the jurisprudence but also the law, followed by law. But again, even in spite of jurisprudence, you lay down the basic things also, you address all the things. And in spite of the law coming forth, it's always been recognized, law is always 10 years behind. And violator or offender is always 10 years ahead. Now I just came across yesterday when I was going through some of the books which are me. There is one book by Julien Benda, a French writer, philosopher of between 1867 and 1956. He wrote a book, La Trahison des Classes. The English meaning is the intellectual betrayal. The phrase denotes, just look at it. I am sure this will be taken note of the subsequent speakers also. The phrase denotes a compromise of intellectual integrity by writers, artists and thinkers. So this is other side of the coin. Possibly we are all dealing with this side of the coin. No, think of about that particular group of persons who are the contributors to this innovation, thinkers and all this and that. So therefore, this again, there is one more book which has come just last week. This is by Professor Arvind Narayanan. He is titled Artificial Intelligence is a Snake Oil. He is a professor from Princeton. What he is trying to convey from that book, it appears to be very interesting also. What intelligence can do, what it can't, and how to tell the difference. Please don't try to get away from our civil approach in tackling the problem of yours. Please forget about that principle, because I am sure even the real practitioner also must be finding his own difficulty, even for the complainant or appearing for the in defense also, trying to how best to help the man who is sitting behind. He is not satisfied how many books you have read, how many principles you have called out, or how much you are trying to convince. Whether judge is convinced or not, he is not bothered. He is only bothered about the result. Please give me that so that I want some injunction, or this injunction should be vacated. This is how the whole. This is one wonderful quotation in 1944. This is a quotation from my Billings learned hand, a chief judge of U.S. Circuit Court of Appeals. This was it. What do we mean when we say that first of all we seek liberty? I often wonder whether we do not rest our hopes too much upon Constitution, upon the laws, upon the courts. These are false hopes. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court saves. No constitution, no law, no court can even do much to help it. But when it lies there, in the heart, it needs no constitution, no law, no cause to save it. So with these few words, I sincerely thank the organizers for giving me this little opportunity, and anything for any of the among the audience or organizers from my side, though I retired about 11 years back, and still I am very active in trying to come to the rescue, especially in this legal field. So I am always there. So I thank everyone or the organizer. Thank you, thank you. Good luck, all the best.
The theme and the session is yours.
Are we seeing courts becoming more sensitive to the nuances of music and copyright infringements?
How do you say that a song is original?
I gained a lot of knowledge today. Thank you.